flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
With a full board today, we can approve the minutes that we weren't able to approve last time because of lack of sufficient people. So we're going to do these individually because some people need to recuse themselves who were not present during the meeting that we're voting on. What is your pleasure on the minutes of February 7th, 2024?
Move to accept.
Second.
And all in favor?
Aye.
Opposed?
I abstain.
I recuse. Abstain.
Abstain.
That's the proper term. I'm sorry, Tom.
Okay, we have 4 votes, that's good. Acceptance, what is your pleasure on the minutes of February 21st, 2024?
Move to accept.
Second.
All in favor?
Aye.
Opposed?
Abstain, I was not present.
I abstain also.
As well.
What is your pleasure on the minutes of February 27th, 2024?
Excuse me, March 27th.
Or March 27th, 2024?
Move to accept.
Second.
I abstain.
All in favor?
Aye.
Opposed? And 1 abstention. What is your pleasure on the minutes of April 10th, 2024?
Motion to accept?
Second.
All in favor?
Aye.
Opposed?
I abstain on April 10th.
We did March 27th.
April.
No, we're up to April
This is
10th.
April 10th.
April 10th,
Oh.
he wasn't.
I wasn't here on April 10th, but I think I
Yeah.
was here for the rest of them.
Yeah, I think
You were here for the 27th.
it's 27th.
According
I
to
wasn't
the,
here.
according to the minutes.
Yep.
I don't remember, but
Right.
according to the minutes, I was here.
You had me, Karina, right? That's when I'm here.
Good thing for Karina to tell us when we're here and when we're not here. All right, we got that done. Now, public hearings. A 022056, Alexandra C. Fraden and others as trustees. They request an adjournment to June 26, 2024. Is there anyone in the public who would like to speak on this application, or anyone on Zoom?
Motion adjourned, June 26, 2024.
Second.
All in favor?
Aye.
Opposed? CB 22013, MIR Noyak Realty, Inc. This has been opened and adjourned, but you may present your application.
Chuck, you
And I
had,
apologize for that, and I have had spinal surgery and everything, so I couldn't get here,
glad you're here.
even though I'd love to be here to see you guys.
Do you have anything new to hand in tonight?
No, I think the record is complete. I think the board should know, we didn't ask for this hearing. We asked to legalize the structure that was built in non-conformance with the permit that was issued by the Conservation Board. So that's what I'm here for. Now, I know there's neighbor concerns. However, I'd like the board, I hopefully will take a look at the original subdivision map for Rawson Estates, which was filed in 1991. And it was very specific on where stairs should go and who should share them. Our client, MIR, happened to have the lot that had an existing stairway on it. And that existing stairway was, and actually, you really have to look at the verbiage in the subdivision map. And I could certainly read it to you if you'd like. But on lot 14, which is our lot, it basically said that is the only lot in the subdivision that could maintain its own stairway access to the beach. All the other lots had to share common. Our neighbors to the east were not supposed to be sharing it with Lot 14, MIR. They were supposed to be sharing it to their next neighbor to the west. How that happened, I know there's an easement in place, former owners granted an easement to each other, former owners of Lot 14 and the lot to the west, which I think there's a copy in the file, of an easement allowing each other to build on their common lot line, MIR and to the west. That actually was in violation of the subdivision plan. Subdivision didn't allow that. No one went to the Zoning Board of Appeals to change the requirements of the subdivision. They just decided amongst themselves, two owners, to allow, to change the subdivision restrictions. I know that's gonna be an issue, but my experience is, you know, I live in a subdivision in North Sea. I can't just give to my neighbor an easement that is going to violate the covenants of the subdivision without going to the Zoning Board of Appeals, which I actually just did just recently. We're gonna try to give a neighbor a relief. You know, that never happened. Those stairs that were built years ago, my client bought the property in 1995. My client was trying to maintain it. The owners of that property never wanted to participate in maintaining it. It got destroyed by the storms, as most stairs on that area do. And so we applied in conformance with the subdivision map to rebuild the steps on his lot alone. And that's what, how it occurred. But I say it's really important to read the subdivision map. And again, I'll read it to you. It says, access down the face of the bluff on lots 12 through 16 shall only by means of a suitable structure locating on or near the common lot lines of 12 and 13 and lots 15 and 16. Okay. Lots 14 is the only one, which is our lot, is allowed to have its own because it was already there. So that's the not even an issue. That's what the subdivision map says. That was approved in 1991. So if a claim is being made that they have a right to use this, somebody would have to go to the Zoning Board of Appeals and change the subdivision map. You can't just do it on your own. Say, hey, you know, I'd rather change what the planning board had administered and approved in the past. The other question, which I certainly agree with Marty on, is that the stairs was not built in conformance with the plan. No question about it. I mean, I was out there today. The question that I have, and we're certainly willing to work with staff on what it wants to do, there's been a lot of erosion all along Rawson. Not a surprise. We have the gabions to the east. We have the bulkheads to the west. Rawson Estates has not done any of the work that was approved by staff as far as rocks or anything else. They didn't want to put the money into it. They're just maintaining their own stairway. In fact, the big sign is that use at your own risk, because there's no beach, you know, quite frankly. So the question is, what do we do to legalize the steps that were built on MIR? That's why I'm not here. Not to argue about you know, who has a right to use it. That the subdivision map is clear on where the stairs should be. Absolutely clear. And if somebody wants to take an application to the Zoning Board of Appeals and make a case to them, my client's not going to participate in that for sure, because he's abiding by the subdivision plan. The stairs been built. It is open grate, but it is not in conformance. And I can tell you that the contractor, and probably partially my client, you know, had something to do with the non-conformity with the permit. It's fine. I mean, it works fine. It's still there. They actually have the steps the way they're supposed to be down to the beach that can be raised during the wintertime. It's open grate. The bluff has taken a lot of erosion along the whole area. If you go down Jim Detmer's, I don't know, he's the furthest one to the common area to the east. His bluff blew out because of drainage problems. It's just, no one's ever gonna have a beach there again, my own opinion, because of the gabions and the bulkhead. And I think, I'm not gonna speak for Marty, but I think we both agree it's a difficult place to maintain in the beach because of all the structure. So I'll be happy to speak to and work with staff on what to do to either modify or legalize whatever we have to do. No other work that was within the issued permit has been done on actually any of the lots. As far as the beach work, we had an approval to move some rocks around and put them below high water. We fought with DEC for, 2 years about getting them to agree. And none of that work has been done because no one wants to spend the money. And like I say, they don't even want to spend the money to maintain their own beach stairs, the community beach stairs. So that's where we are at the moment. But I really think it's important that the board reads the subdivision plan. And if you don't, you should have one in the file. Otherwise, I can leave one with you.
We have one.
You have one. Because, again, you just can't decide on your own to write an easement to your neighbor and violate the covenants and restrictions on the subdivision. And prior owners of both lots did that, but certainly it doesn't make it a legal transaction or something that they should have done.
Thank you.
Good evening, I'm Marty Shea, Chief Environmental Analyst for the town. Rather than speak to the subdivision history, my preference is to offer some history in terms of Conservation Board permitting and why this application was filed. And also offer some recommendations in terms of mitigation of wetland impacts. The original Conservation Board permit for MIR Noack Realty was issued November 24th in 2020. And the reason that application had been filed and what the Conservation Board was intended, Conservation Board permit was intended to address was the shore armoring. While there was a prior approval that allowed for a certain number of boulders and rocks to be placed along the shoreline to try and stabilize the erosion trend. At some point in time, rocks were placed in excess of what had previously been permitted. So the initial application had been made to the Conservation Board in order to rectify the stone armor along the shoreline. And what the Conservation Board permit sought to do was to modify the existing armor by removing some of the excess boulders and stone and scattering stone over a wider area, preferably below, with some of the armor below mean high water, in order to break up the tidal surge and wave action before it hit the toe of the bluff. What that permit also did was allow for a centrally located bluff beach access stairway, as well as a stone path leading down the slope to the stairway. And it also sought to address existing fence lines within the scenic and conservation easement, including non-code compliant deer fences and double fence lines across the property as well. It was also noted at that time that there was a fire pit that had no permit close to the crest of the dune that needed to be removed, and there was also some needed attendant restoration and revegetation of cleared areas. The applicant had agreed to those terms in terms of mitigation, so we issued the permit. What happened later, and the applicant can correct me if I don't have the exact history, but the applicant, after receiving the initial Conservation Board permit, sought a DEC permit to allow for the modification of the existing unauthorized stone armor. And there was some significant concern on part of the DEC with regard to the town's preference to place some of those boulders out in the open water. So there was some back and forth communications between the applicant and the town and DEC. The consequence of which was that the applicant needed to come forward with a modified plan to address the existing unauthorized stone armor along the shoreline. So that wetland permit modification application was filed, and that's what this hearing centers on, is that subsequent permit modification application. And again, the applicant was amenable to the mitigative measures that this board had sought pursuant to its original permit. After receiving that modification application, it came to my attention that there was significant public interest in this application, in that it was indicated that there might be a shared common access, and that this board's permitting of a centrally located new stairway might run counter to an existing shared access easement. So as is consistent with protocol, as there was significant public interest, I recommended to this board that a public hearing be scheduled to provide an opportunity for the applicant and the public to speak to some of the concerns regarding the permitted central location for a new stairway, and how that might run counter to any shared access agreement. There was also concern raised regarding fencing on the property, not only fencing within the bounds of the scenic and conservation easement that was established as part of the subdivision map, which again the applicant agreed to remove and/or reconfigure landward of that easement. But it was also expressed to me that some of that fencing, particularly the perpendicular fencing along the side lot line, was interfering with apparent common shared access. As was indicated by the applicant, the initial Bluff Beach access walkway was heavily damaged by a storm And that was the reason why they sought this board's approval as part of the shoreline reclamation to install a new stairway. Upon receipt of the wetland permit modification, I had inspected the property, and at that time, I had found that the applicant had proceeded with stairway construction, and while that stairway was positioned generally where this board had permitted a new stairway, the stairway was reconfigured in a manner that had not been permitted by this board. The new stairway was constructed in a manner consistent with current environmental standards, in that it's a light penetrable decked stairway. So I also advised, as the applicant spoke to, that as part of this pending wetland permit modification, that we would need to legalize that stairway. I did have an opportunity also to return to the site. I was at the property yesterday, and as was alluded to by the applicant, the site conditions essentially have not changed, with the exception of this reconfigured stairway being installed that needs to be legalized. And yes, there is some significant erosion along the face of the bluff that would be appropriate to address, perhaps by a revised bluff revegetation plan, which I'm sure the applicant is amenable to. At the time of my reinspection of the property, I also noted that within the area of concern, I'm part of the neighbor where a prior stairway had existed that essentially straddled the two property lines, that today there is yet indeed a fence line that would interfere with or prevent access to the new stairway, if that is something that the abutting landowner has legal rights to. Again, I didn't review the entire subdivision history, so I'm not going to speak to that. My preference, when there are questions regarding a subdivision history, that the planning division look at that and provide any needed information to this board if this board has questions regarding the covenants of that subdivision. So, putting the matter of any legal rights to shared common access to that new stairway aside, environmentally, the new stairway that has been constructed can otherwise be legalized because it's consistent with current standards and requirements for a light penetrable decking. The applicant has already agreed to remove the unauthorized fire pit, and also to work with my office in terms of any needed restoration and revegetation, not only within the bounds of the scenic and conservation easement, but also on the bluff face. So in addition to those earlier recommended mitigative measures, which the applicant has already agreed to, consistent with this board's protocol for other properties where shoreline armor is being permitted, whether that be rock or bulkhead. I would ask that that any modified permit be conditioned upon the establishment of a covenanted, naturally vegetated wetland, non-disturbance, non-fertilization buffer. The intent of that would be to provide protection for the naturally vegetated bluff face while still allowing for restoration and revegetation. It would also close an apparent gap between the existing scenic and conservation easement, which is focused on the land atop the bluff, and the waters of the Little Peconic Bay. Within the recommended covenanted naturally vegetated wetland, non-disturbance, non-fertilization, no structures, with the exception of the stairway, would be permitted, which is essentially the same condition that is applicable in the bounds of the scenic and conservation easement. So in light of that restriction, any existing fences, not only within the bounds of the scenic and conservation easement, but also within the bounds of this recommended supplemental covenanted naturally vegetated buffer, would need to be removed. Beyond that, I'm happy to work with the applicant as far as any needed updates and revision in terms of bluff reclamation and revegetation, because there is additional erosion that's occurring on parts of the bluff, not only at this property but on other properties. As was indicated by the applicant, the stairway that has been constructed is solid, it's intact, so there are no issues in terms of erosion-related destabilization of the stairway. So consistent with wetland permit standards, notwithstanding any remaining issues in terms of possible rights to shared common access, the constructed reconfigured stairway can be permitted and legalized by this board. Thank you.
Marty, a question. Their testimony has been that there is significant erosion in this area, particularly on this bluff. Would you characterize that erosion as being caused by, or predominantly caused by, rainfall, as in runoff, or Little Peconic Bay with a storm surge eroding from the toe of the bluff?
There's a combination of events and factors that are causing the erosion. What is commonplace along many bluff lines and can be observed along this stretch is you get a lot of groundwater seepage that comes out of the bluff face, and those rivulets of water cause some of the erosion. One of the reasons why it's preferable to have a light, penetrable, through flow decked walkway is that provides for a greater area of rainwater infiltration where that stairway is, because when you have hard surfaced wooden stairways, that causes some channelization of rainwater and runoff, and that oftentimes results in significant gullies under the stairway, which can worsen the erosion. But yes, the vertical shear of the existing bluff combined with storm impacts is a major factor in the erosion. Often times when you have excessive rock that's placed at the toe of the bluff in a manner similar to a revetment, it can actually worsen the erosion of the bluff toe because there's nothing to break up that wave energy before it hits the rock. So it will slam into the rock, it'll overwash the rock, gouge out the bluff behind it. And the second thing it tends to do is cause more significant erosion on the seaward side of the rock. So that's the reason why the applicant and I have worked out a plan where essentially a scattered boulder field would be created so that a lot of that wave energy and tidal surge is broken up before it slams into that bluff toe. So there's actually a combination of factors at work. The area atop the bluff, with the exception of the areas of clearing, which are being maintained as lawn, which again need to be addressed by a native planting, there's no evidence that those areas are contributing significant runoff over the crest of the bluff and down the side of the bluff. The large majority of the scenic and conservation easement is well vegetated with natural vegetation. At the same time, you always want to minimize any lawn right at the crest of the bluff because it can generate runoff over the bluff face and contribute to erosion of the bluff as well.
Thank you.
All right, thank you.
Very, very shortly, Marty and I have been spending an enormous amount of time over the years on the whole Rawson Estates. It's a tough area. The larger boulders that were put in violation of the original permit to Rawson Estates are basically now offshore, and the high water mark is landward of them. One of the difficulties is that the beach area is a park for Rawson Estates. So that's why Marty and I are basically fighting with DEC. The DEC wanted a permit for everything, The town wanted individual permits so you could hold people, accountable for their individual properties. DEC didn't agree with that. So it was a lot of back and forth. Finally, they got a permit approved. We don't have any problem with meeting the existing conditions of the permit, removal of the fences, removal of the fire pit. The bluff restoration, can it be done? Yes. I'll have to talk to the owner about that, which I already have. It's basically to the east side of the stairs where it has. My own personal opinion, a lot of it has to do with storm surge. We all know that bluffs erode just naturally. That's how the beach gets there, and there's no beaches there, So that's why the whole Rawson Estates subdivision has elected not to rebuild their community stairway because there's no beach to go to if they go down the stairs, So that's certainly a problem to face. Plantings, sure, we can try that. Do I think that they're gonna last long? I think this erosion is gonna continue. I have no problem with getting input of the planning department on this, because that's my concern. Because, again, obviously I'm not an attorney. There was an attorney representing the adjacent homeowner before. I had many conversations with him, and the subdivision map is certainly very plain. The easement was done after the subdivision but from what I could find with the town, no record of any application to the planning board, the ZBA, or anything else to change the conditions of the subdivision. So, you know, if you want to consult with the planning department, great, that's fine. No problem at all. So, and with the other mitigative measures, I certainly can work with Marty on.
So you agree to a revegetation plan and covenant for the bluff area?
Yeah, the covenant, I gotta look at the survey, Harry, and see where, because part of it's park land, it's the whole
Yes,
association.
I'm looking at the survey, and there is a park area, and then there's the bluff area, which has no apparent protection,
Right,
at least according to the survey.
the
And then,
as-built survey,
and then there's the 50-foot scenic and conservation buffer, which is protected.
right.
So there's that gap there that may not have protection that we want to make sure is
Sure,
protected.
I don't think that's a problem.
Okay.
That's not a problem at
Okay.
all. You know, again, it's just, it
that's-
complicates things that some of it's owned by the whole association, some of it's owned by individuals.
Sure.
And, yeah, it makes it a little bit more complicated. That's all.
Okay,
But,
okay, okay.
Just in clarification, the area that I'm recommending be covered by covenant and naturally vegetated buffer is just a bluff face within the bounds of the applicant's property. I'm not asking that the park area be covenanted. You know, I just think we need that extra protection to ensure that the bluff remains naturally vegetated and consistent with other covenants that are recorded as conditions of wetland permits. The covenant, of course, will include the necessary language that allows the landowner to work with my office on any needed restoration or revegetation. But you know, consistent with board decisions on other properties where any kind of shoreline armoring is approved or bulkheading. Yes, that face of the bluff only within the bounds of the applicant's property needs to be covered by a covenanted naturally vegetated wetland, non-disturbance, non-fertilization buffer.
Thank you.
There, I might mention in the file, there is also a reclamation plan that the applicant had submitted that depicts the intended larger boulder field in contrast to what you're seeing on the survey. So that may be helpful to look at as well. Thank you.
Is there someone in the public who would like to speak in this application?
I suppose. I'll submit things into the record. Date of the exhibit. Just some things I wanted to point out or discuss. Good evening, board members. Robert Marcinczuk, O'Shea Marcinczuk and Bowen, 250 North Sea Road, Southampton. I represent Patricia Finn, who's here tonight, as well as Philip Kozlowski, who are the owners of 27 Rawson Road. That property, their property is located adjacent and immediately to the southwest of the MIR property, which is the subject of this application. As Mr. Bowman might have pointed out previously during his presentation, the Finn Kozlowski parcel is designated as lot number 13 on the subdivision map of David R. Swanson, among others, and Rawson Street Associates, while the MIR parcel is identified as lot number 14 on that subdivision map. I've actually included, I don't know if there was part of one in the record, I've included as Exhibit A in the exhibit packet, the subdivision map showing the location of those two lots and their relationship to one another. We're not here to necessarily object to the construction of a beach access stairway, but we are here to talk about and perhaps object to its location and the applicant's failure to recognize and abide by the declaration of covenants and an easement that burdens the applicant's property and benefits the Finn Kozlowski property with regard to the location and access and the use of a stairway to the beach from the MIR property. Since 1995, my clients had benefit of an easement over the MIR property for the use and enjoyment of a common access stairway to the waterfront. I have included a copy of that declaration creating the easement, which is Exhibit B in the exhibit packet. The declaration was entered into by Patricia Finn and the former owner, who was also the developer of the subdivision, David Swanson. The declaration provides that there be a common access to the beach in favor of and for the benefit of my client's lot over the subject parcel, and any access stairways to be located as at the common property boundary line between these two lots, unless the topography and natural conditions prohibit it being built in that location, in which case then the access stairway shall be located as close to the common property boundary line as is reasonable. The easement, you will see, also states that there's a 10-foot wide pedestrian access over the MIR property from my client's property, from the common property boundary line to the stairway. This declaration goes on to affirmatively state that any plans for the access stairway, future plans for its change, shall be approved by both parties to the declaration. We submit that this declaration does not in any way violate the declaration that was filed in connection with the subdivision. If you read, we'll get to that, but if there's nothing in the declaration imposed by the planning board that prohibits any landowners from granting an easement to allow a staircase to be used, I would submit that it actually was the intent of the planning board that the number of staircases be limited. And one of the reasons, we'll get to this, in the covenant and restriction that was filed in connection with the subdivision, which basically said, other than lot 14, where there was an existing stairway, but as far as other lots, that they recommended that any proposed staircase be located in close proximity to the common property boundary lines. We would submit that that was in an effort to minimize or reduce or limit the number of stairways that are going to go down the bluff onto the down to the waterfront. So I would submit that the declaration and easement that was entered into by my clients and Mr. Swanson was actually in furtherance of the planning board easement. In any event, we submit that the applicant has completely failed to comply with the terms and conditions of the declaration between my clients and the MIR property owner, prior MIR property owner, in that the proposed stairway is not in close proximity to the common property boundary line. My clients have been denied access to and the use of the stairway, and they have not been consulted or given or requested their approval for the plans to the stairway. Previously, it was located in that stairway on lot number 14. The MIR property was located in close proximity to the common property boundary line. Its prior location was shown in a survey which is dated December 19th, 2019, and is shown in the Exhibit E in the exhibit package that you have. And we also have some aerial photographs from 2021 as Exhibit D, which shows the prior location of that stairway. It was utilized by my clients during that time. However, after storm damage to the stairway has resulted in the applicant now requesting to rebuild and relocate the stairway away from the property boundary line, and in essence prohibit my client's access and use of the stairway to the bay, despite the clear and unambiguous language in the declaration that burdens the MIR property. In fact, as I think Marty had indicated, the owner has installed a wire fence to keep my clients from entering the property and using the stairway. We've taken some photographs of that wire fence, which is included as Exhibit E in the exhibit packet. On many occasions, my clients have offered, pursuant to the easement that they enter into, to pay for their fair share, one half of the construction cost of the stairway. And they have, their prior attorney has actually submitted numerous letters to MIR, basically advising them of this. We've included those letters as Exhibit F in the exhibit packet. We would also submit that the applicant's stairway is actually in violation of the declaration recorded in connection with the approval of the subdivision by the Southampton Town Planning Board. Paragraph 20 of that declaration, which we've included as Exhibit G in the exhibit package, I think as Mr. Bowman had indicated, stated in pertinent part that access down the face of the bluff on lots 12, 13, 14, 15, and 16 shall be only by means of suitable structures located at or near the common property boundary lines. It then did indicate that the existing wooden steps on lot 14 could remain in use, but it went on to indicate that stairway structures shall be designed and constructed in a manner that results in the least disturbance to the bluff and must be approved by the planning board of the town of Southampton prior to construction. So the recorded declaration between my clients and the former owner of the subject MIR property also provided that the construction of any staircase be approved by the town of Southampton Planning Board. So the plain language of both the declaration between my clients and the former owner of the MIR property, as well as the covenants and restrictions imposed by the Southampton Town Planning Board, both state the intent of the declaration that the stairway to the water would be in close proximity to property boundary lines, and the construction must be approved by the planning board of the town of Southampton. The proposed location of the stairway has been moved away from the property boundary line, and my client's access has been denied. The stairway has not been approved by the planning board as required by the covenants. Accordingly, we request and submit that further consideration of this application should be delayed until the issue of the access has been resolved and the applicant obtains approval for the stairway from the Southampton Town Planning Board. And contrary to what Mr. Bowman said, the Zoning Board of Appeals has pretty much nothing to do with any application for the stairway. It would be the Southampton Town Planning Board. If you read the end of the planning board covenants, it expressly states that any change to any of the covenants, to that covenant, would require the approval of the planning board. Zoning board has nothing to do with it. But I would submit that our covenant, the one that we entered into, the private covenant, does not in any way violate the planning board covenant. And I think your council can review both and opine on that at some time in the future. That's all I have, unless you have any questions.
This is a question of ignorance.
Then I'm your man to answer the question then. Is that what you're saying, George?
That's it.
Okay.
Why are you pleading this case before the Conservation Board?
Pardon me?
Why are you pleading this case before the Conservation Board? I don't
To bring the
believe,
Conservation Board's attention to the requirements under the various covenants. So that the the Conservation Board doesn't necessarily start approving something which may later prove to be changed. So for administrative economy, so this board does not grant approval, which the planning board might disapprove of the stairway, or in the event that my client chooses to commence a lawsuit against her neighbor to enforce the private covenant between the parties, which may result also in a relocation of the stairway.
So
So I'm just
I
making you
see-
aware of that.
I see your argument as if the stairway wasn't there yet, and you wanted to stop us from giving them permission to build it.
Well, it was
The
built,
location that
it
they
was
were
built
applying.
without approval to
But-
begin with, wasn't it? So it shouldn't be where it is.
It shouldn't be
Correct.
where well, the location, we can't necessarily ask them to move it if the staff and we don't see any environmental impacts from where it actually is. If it wasn't there already, I would say we could always table this until the planning board renders a decision. But if we're looking at the environmental impacts and we don't see any impacts from where it was erroneously put, there's no real impetus for us to tell them to move it unless you're talking about a planning board
Oh, I think the
decision.
planning board has
So
to,
you're trying to put us on notice that you're going to the planning board and they may say, we don't like
I
it
don't know if
where
I
it
can
is,
go to the
move it.
planning board. I'm saying that they can't have approval. I think that this board should refer this matter to the planning board for approval, or suggest that the applicant do so. I don't think that my clients can do that.
Well, your
They can't
argument,
submit
your
an
argument is hinged
application
on the planning board
For the
approving
planning
it,
board,
so-
for the approval of a structure that doesn't exist on their property.
We're looking at
But
the
as I said-
environmental impacts, we're not always looking at whether there's a dispute between neighbors about an easement.
No, I understand it's a private covenant,
I mean,
but what
if-
I'm
if
trying to
the-
say
if-
is that the applicant, in addition to this board, should be going to the planning board.
So you're essentially saying you're using the conservation board.
I'm just alerting you to
Forget-
the fact that
I-
there
I
are
didn't
additional
finish.
approvals
I
that are
didn't- I didn't
necessary
finish.
besides this
I didn't
board.
finish.
Okay, I'm sorry. I'll let you finish, George, my bad.
So what you're saying, without being, you're using the conservation board to get this issue before the planning board.
I just don't want this board to take an action without being aware
Well, I don't see
of
this,
all of
I
the
don't see how we
approvals that
can,
may be necessary.
I interrupted you now. I don't see how we can resolve the covenant issues. We can
We might
resolve,
not be able to.
we can resolve the environmental issues, but we cannot resolve any of these covenant issues, whether she has a right or doesn't have a right to use those staircases. I don't see how we can resolve that, but we can resolve where the staircase is placed and the surrounding area, creating a buffer, making sure the fences are removed. We can do that, but I don't see how we can resolve any of this covenant issue. That's why I asked you, why are you pleading it? And
Well,
I'm
again,
following
I-
it up with, are you pleading it to use us to get this to the planning board?
I'm just trying to make
Because your
this board
client's
aware
not-
of what the various covenants state. Specifically, if not the private covenant, certainly I think this board should take notice of the planning board covenant that requires their approval for the construction of any stairway. It clearly states that.
Rob, I understand what you're saying. I believe I do. Generally speaking, this board does not interfere with private covenants.
I understand
The
that.
owners of private covenants have another forum to go to remedy that. But you're making us aware of another issue that may be relevant here. I get that.
Mhm.
Now, I would like to ask Chuck a question.
Yes, sir.
You indicated that you have read the planning board decisions, and my
Yes.
question to you is, have you gone to the planning board as the previous testimony indicated was necessary?
No, and that's where I'll disagree with Rob. I mean, when I mentioned ZBA or the planning board, I don't know which one you'd have to go to, actually. So the planning board, great, we'd have to go to the planning board. Our property, lot 14, was the only lot that was allowed to have a private stairway. Our stairway is on lot 14 as reconstructed. Lot 13 was supposed to share, Rob is absolutely right, share the stairway with lot 12, the lot to their west, not with ours. You know, and that's what the subdivision map says. I agree that the
I
planning board
understand
was
that.
supposed to,
That's not my question.
okay,
I understand that. Apparently, there's a private covenant. I don't want to speak to that either.
right.
What I want to speak to is that Rob suggested that a stairway approval must be approved by the planning board. And you have requested a stairway approval through a board other than the planning board.
Not on lot 14, because it's the only lot that was exempted to have its own stairway on the lot, on their lot. If we try to change it to another lot, yes, we would have to go to the planning board to change the subdivision covenant. But our lot, lot 14, was exempted for that because there was an existing stairway there. To move it 50 feet east or west, I suppose one could make a case that you'd have to go to the planning board and ask them if we could move it 50 feet east or west on our own lot. I don't think that would happen. I don't think that's necessary, personally. You know, if we tried to move it to lot 13, we should have gone, you know, the original signers of that easement should have gone to the planning board and asked for permission to do it. They didn't. You know, the stairway was built there, it was taken out by the storms, okay? It was basically an illegal structure at that point, you know? So we're back to square one. How do you conform to the subdivision map and the covenants on the subdivision map? That's all we've been trying to do. So we're not gonna go to the planning board, you know? If the neighbors want to commence an action, God bless them. You know, that's fine, you know.
So you believe that you can receive a CO based on this board's approval of the permit that you came to
Oh,
us for?
of course, because it's on his lot, and it says right on the subdivision map, the lot 14 is allowed to have its own stairway, period.
Can I just ask something?
Sure.
The existing wooden steps, this is here in chapter 20. That's on 14. That was near originally the property line for the neighbor, that they could then use that
Okay.
to get down to the beach.
I'm just, you tell you about when the subdivision was
Yeah,
approved?
yeah, and they
No,
allowed
no,
for-
no, when the subdivision was approved, the existing wooden steps were on lot 14. When there was no subdivision, it was a vacant, large piece of land.
How close, though, to the?
Oh, it's probably 50 to 75 feet away from where the stairs are now. Maybe.
But
I
it
mean,
was-
we picked the
It was
spot.
close to the property line.
It was
Yeah.
close.
it was-
Yeah, so,
yeah.
because then if you look at the first sentence, access down the face of the bluffs on lots 12, 13, 14, 15, and 16 shall be only by means of suitable structures located at or near the common lot lines of lots 12 and 13 and lots 15 and 16. So 14 didn't need to be addressed, it already existed, but it was near the adjacent property line, giving them access.
Well, the
down to the
subdivision
beach.
map actually shows where the existing stairs were, you know, on lot 14. And it's not near the property line, actually. You know, it's near, if you want to look at it as being near any property line, it's to the property line to the east, not to the west.
It wasn't close to lot 13's property line?
No, not at all. In fact, it shows right on the subdivision map where it was. It shows deck, I'm looking at it right now, it shows deck and stairway.
Your original argument was that any easement granted between the previous owners and the neighbors is not valid because it violates the subdivision.
Correct.
Okay. Wouldn't going to the planning board resolve the validity of that easement and let them say you can't make a private easement?
They're
So-
more than welcome to do that.
And this is,
Yeah, you know, again, you know,
And then with
we're
the
going by
houses,
where, and that's this whole thing with the Ross
Here,
estate.
the original covenant.
Is that the location of
The
the
original
original staircase?
And you can't violate a covenant, then get them to change law 101.
You didn't have it upside down, did
You
you, Joe?
can't make a declaration between two people going against it.
right, right.
Because this is a survey from 2000, from,
Where, this is the indication of where it is.
It's right there.
This is lot 14.
That's lot 14. This is the neighbor. It's closer to lot 15.
So how did the staircase get placed here?
Well, we moved it over to here.
why does the
Wait a
survey from
minute.
2019 show it over here?
That was the proposed one, Tom, if I remember correctly.
It doesn't say proposed, it just says with steps,
Is
and there's
that-
a slate walk that goes
Open
right
that up
now
and see
on.
if that's a survey.
It's a survey, it's from 2019. 2019. On the survey we have, there's a slate walk that goes down to nothing. And on the 2019 survey, it's a slate walk that goes down to something. So,
Well, I have another survey that I can
There's an area
give you
showing
that shows the
from,
existing and the proposed.
the former stair.
so it shows, well, through the trees, you can see the walkway coming down, and then it goes to the stairway, which is in this location. And this, it doesn't say proposed, it doesn't say existing, it just
Well,
says
no,
with
but that's-
steps.
but that's the
But
one-
that slate walk is the same slate walk that's on the
Right, but
current
that's the
survey,
one
so it's
that
going
was-
to
that-
nothing
that's the one
before it
that
went to
was-
something.
But that's the one that was taken out by that was destroyed too.
That's the one
So-
that they shared, generally, they shared in violation of the subdivision.
So when were the stairs closer to 15?
When the
'Cause there's no
subdivision, this is the subdivision map. That's the original stairs. The subdivision covenant said that on 14, they could have their own. If you're gonna have a stairs on 13, they're supposed to share it with 12.
No, we get that. So in other words, it was in the location closer to 15 before this was all approved, and
Right.
didn't need to have anything specifically
Right.
mentioned, which it probably should have, it would have alleviated all
Right.
this. And then it was somehow moved
Correct.
to 13 again, with permission by who?
Well,
Altogether,
it was
class?
still mostly on 14, I think your survey's gonna show. It was right on this property line, but that was based on.
This
the
one shows
easement.
it there, you told us
Okay,
it was
I'm gonna
originally over
suggest
there, and
something.
now it's in the middle. So
I
it's
think
been
you should
moved
put a-
illegally
at
twice?
least Put a call into Moses.
Yeah.
So it's either been
Okay,
moved without
let's,
permission
let's wrap
twice,
this up.
or...
I want to suggest something. Before I do that, I'm going to ask if there's anyone on Zoom that has their hand raised.
Oh, forget about
Okay. There are a number of questions here.
Sure.
They're being interpreted by each of us who happens to read it and look at things. And it just turns out that none of us have the authority to interpret it.
I agree with you, 100%. This is something that,
So-
you know, if someone wants to go to the planning board,
I'm
God
going
bless
to,
them.
I am going to propose that we adjourn this hearing to a future date. And in the meantime, I might need some help on this because I don't know what the protocol is. I believe the planning board should lend their voice on this. The question is, how should that be done? Should it be done internally or should it be done by the applicant?
Well, typically when the applicant, typically when a private landowner does it, I believe they have to file an easement interpretation application with the planning board. But that doesn't necessarily prevent this board from,
I mean, this board, we could refer it to the planning board for their comments and ask for their comments. If the applicant is not willing to do that on their own.
well, we're not gonna do it,
Well,
you know.
until that happens,
don't-
I could make a suggestion that we take no action. I mean, take no action at all until we get clarification. Otherwise, I don't see where we're the board to be
Well,
approving it or denying
We-
it. without clarification.
I don't think it needs to be a long, drawn-out affair to get the planning board's blessing on this action. But I believe it's important also that they be involved, because they're the ones that drove this in the first place. And we don't want to preempt them. That's not our job to preempt them. And we don't want a future issue to come up because they weren't consulted.
We agree with you. You know, I
So-
don't think this is the right forum to argue about an easement and the
So
validity
we've
of it.
addressed the environmental concerns.
Yes,
And we would be willing, likely be willing to give a C of C for work when it's completed. However, that may not be sufficient for a CO on this project by the building department.
I agree.
So let's
100%.
cross that bridge, get it done right, find out exactly what needs to be done, and find out what their concerns are. They can voice their concerns. It may not be the concerns that we're expecting.
Yeah, you know what, again, I know
Uh,
you all, we all are, have been
So
involved
that,
in neighbors'
now,
disputes.
that is going to address the new location for the stairs.
Yes.
The issue for the neighbors' easement is not being addressed by this.
Correct.
That will need to be done in another forum. We don't have that authority, and we don't get involved with private covenants. And I'm not speaking to the validity of it or lack of validity of it. It's not, this is not the ballpark for that.
I'm not either.
So,
You know.
I think it's important that this be done properly, so that at the end of the day, everybody can sign off and say, yes, this is right. This is where we're gonna go ahead.
I think we all agree that the planning board has to decide what standards in that subdivision map are adhered to, and whether or not the easement that was granted between two owners in a different place is valid or not. And that's fine. We don't have a problem with that. We're just, you know, we're just not planning on
So-
going there.
If we do this internally, who would take that action? Would it be through legal or through,
Would generally be, you can do it either way, refer it to the planning board and see how they wanna handle it, at least just to get comments, you know.
okay?
Just like, you know, other boards, we get referrals from the planning board, you know, so,
Okay,
So there are essentially two questions that the planning board needs to ponder. Number one, the fact that they didn't list lot 14 in the subdivision approval, does that indicate to them where they would think they gave permission for the stairway to be, lot line side, or anywhere that the person wanted to put it in? Second of all, do they agree or do they want to disagree with the private easements that were given between a prior set of neighbors and in relation to the validity of the subdivision approval? So those are the two most important things, is do they agree with the easement in the first place? And also, did they have a preference of where that stairway would go, were to go, because it's not in any of the approvals?
yeah, I mean, I
Well,
think.
my-
It should have really been in there first.
My
place.
preference is not to even speak to that, rather to just
I think-
refer the matter to
right,
the
it
planning
would
board to
be
see whether or
what their
not this
comments
board's
are.
We can leave it open.
legalization
Right.
Sure.
of the constructed stairway in its current location requires planning board approval.
Yes,
And,
whether approval is needed or not.
Yeah.
And if no, then fine.
Okay.
you know, unless you wanna go further.
No,
but,
no, no.
Oh, Kelly, come on.
I mean, I honestly, I don't think they're going to get involved in a personal covenant issue. They're going to look back at their original approval, the subdivision map, and the declaration that was filed as a condition of planning board approval, and determine whether or not they need to issue any permits in order to keep the stairway in its current location.
So right now, you think the planning board is not gonna resolve their problem, they're gonna have to go to a higher authority?
I don't think they're going to resolve their problem as far as the private covenant, because
Yeah,
a
that's
planning
right.
board cannot interpret a private covenant. That's a matter that has, only a court can interpret a private covenant. I think that they will resolve it as far as the original declaration that was in this paragraph 20, this was recorded as a condition of planning board approval. So they can look at this and see if there's any issue with keeping the stairway where it is.
How much time do they need? Should we adjourn this for 1 month?
I would think so, because we have to get this on the agenda for their next meeting and then get their comments back.
Is 1 month too soon?
I think 1 month is too soon.
Yeah, you think so?
How about 2 months?
6 weeks?
And I
2
think-
months.
I would do 2 months.
I think you're gonna need to allow 2 months.
2 months.
Okay.
I mean, the stairway, it's already there, it's not being used.
I don't know.
It's
I
not
mean,
summertime.
They can, we can.
Who's got our social calendar? What's going on in 2 months?
June 26th?
Don't we hope?
June 12th, I'm sorry, today's April 24th, June 26th.
Do we have anything on there for June 26th?
Two things that people keep adjourning even though I don't want them to, and they could go to July 10th, we only have one thing on July 10th.
Let's, what's on June 26th?
In Peru Revocable Trust, 14 adjournments, and Freyden.
Let's do June.
6.
This is, the next time we come back will be short and sweet. We either have authority to do what we did, or we don't have authority. We don't need to, and if we have authority, we're done. If we don't have authority, you're starting over with them.
Yeah, I'm
So
gonna move
there's
that we
no
take no action if
really-
we don't get it.
Yeah,
If we don't get something from the planning board, we take no action.
and you guys have to go in a separate way.
What's the date?
June 26th.
June 26th.
Okay,
So I think 5 minutes and we're done. Let's do June 26th.
very good.
Motion to adjourn until June 26th.
All in favor?
Aye.
Opposed? Thank you
Okay.
all, and good luck.
Turn in your trash. You keeping yours?
No, you can, I don't need any more papers. Oh, one more thing for the record, now that we already adjourned this. Tom has brought a correction here. I introduced this application as CB 22013. It looks like it actually should be CB 20013.
Yes.
We're gonna have to start all over.
Yeah. Everything in
Just
the
want to get
file-
that on the record. I don't know what the accurate thing is, but it's MIR Noyak
The
Realty on
folder-
29 Rawson Road.
We all know what
Noyak.
we're talking about.
We do. We sure
Folder
do.
caught my attention, and all the documents inside said 20013, just so Tom's correct on the agenda.
Okay, thank you. Advisory reports for the planning board, 254 Noyak Road.
You mean 254 Tuckahoe Lane?
Where'd you get that?
Oh, what did I say?
Noyak Road.
I'm looking at the wrong place here. 254 Tuckahoe Lane, lot line modification.
Good evening again, Mark Shea, Chief Environmental Analyst for the town. This is a lot line modification that involves two residentially developed lots located on Tuckahoe Lane in the hamlet of Tuckahoe. There are two recommended comments. The first indicates that there are flooded state and town regulated freshwater wetlands to the immediate west across Tuckahoe Lane. However, town wetland permits are not required for future land disturbance, and construction activities are proposed lots 1 and 2, as such activities would be located on the opposite side of a paved road, nor is a section 292-39B referral needed. And second, based upon field assessments completed on April 12, 2024, and April 19, 2024, the track is marked by some large mature trees whose preservation is warranted as a value for their carbon sequestration, songbird habitat, and air and water purification benefits. As such, those trees with 12 inches DBH or larger should be surveyed, shown on the subdivision map, and protected to the maximum extent practicable.
Move to send these comments to the planning board?
Second?
All in favor?
Aye.
Opposed? Tuckahoe Orchard LLC.
This is a pending subdivision map. It's in its final stage for property on North McGee Street in Tuckahoe. There are two recommended comments. First is that the track is located within 1.5 miles of documented federally endangered northern long-eared bat occurrences. As such, notation needs to be added to the subdivision map that, quote, guidance will be sought from the New York State Department of Environmental Conservation with regards to any applicable legal NLEB protections or restrictions on tree removal, end of quote. And second, the subdivision map of Tuckahoe Orchard LLC as prepared by Fox Land Surveying, last dated October 4, 2023, and stamped approved by the Suffolk County Department of Health Services on November 3rd, 2023, is otherwise consistent with the recommendations of the November 16, 2022 Conservation Board Advisory Report as related to wetlands, open space, and steep slope protections, and thus should be approved.
Motion to send those comments to the planning board?
Second?
All in favor?
Aye.
Opposed? The administrative wetland permits are in your packets. Resolution of conditional approval, A 023049, Jeffrey Ashlower. Any discussion?
Move to issue.
Second.
Resolved that a conditional wetland permit approval be granted to Jeffrey Ashlower for the proposed project upon the terms and conditions set forth therein. All in favor?
Aye.
Opposed? A 023041, Jennifer Standing. This is postponed to May 8th, 2024.
So moved.
Second?
All in favor?
Aye.
Opposed? A 024013, John Lucas Senior Life Estate. Any discussion?
Move to issue.
Second?
Resolved that a conditional wetland permit approval granted to John Lucas Senior Life Estate for the proposed project upon the terms and conditions set forth therein. All in favor?
Aye.
Opposed? Preliminary review signature determination, A 022082, Erlinda Bildner, is postponed to May 8th.
Motion to postpone to May 8th,
Second.
2024.
Second.
All in favor?
Aye.
Opposed? A 023022, Guillaume Savadier. This is postponed to May 8th, 2024.
Motion postponed to May 8th, 2024.
Second.
All in favor?
Aye.
Opposed? Resolution to issue modified conditional approval, A 023043, Vito Marzavilla and Adriana Marzavilla.
The draft resolution before you speaks to the history of this property for the board, indicates that this board had granted a conditional approval in October of last year in order to allow for significant residential redevelopment activities at the property, including, among others, a two-story addition, garage addition, covered patio, new in-ground swimming pool, various decks and patios, as well as upgrade of the current sanitary system. The board's approval was conditioned upon establishment of a naturally vegetated wetland, non-disturbance, non-fertilization buffer, landward of the existing scenic conservation easement, and that was to be achieved by fence removal and town-approved native planting. As a consequence of such conditional approval, the applicant decided to evaluate practicable alternatives in the interest of significantly scaling back the extent of proposed improvements. A modified conditional approval is now being sought in order to allow for replacement of the existing swimming pool in a footprint that is further landward, replacement of existing deck area, and brick pool patio with new pervious patio that would essentially be in the same footprint. And then there are a few other minor amenities, including an outdoor kitchen and gazebo that would be built as well. These changes to the original project plans are significant, and there is no aspect of the modified plans that would warrant the need to establish the previously recommended supplemental natural buffer. So the resolution before you recommends that the modified project plans be approved without the requirement for expansion of the easement by establishment of a covenanted buffer.
Motion issued, modification.
Second.
Resolved that a conditional wetland permit approval be granted to Vito Marzavilla and Adriana Marzavilla for the proposed project on the terms and conditions set forth therein. All in favor?
Aye.
Opposed? Resolution to issue wetland permit modification, CB 20033, Tiana HB LLC.
This application, which seeks a modified wetland permit, relates to property fronting on Tiana Bay and Hampton Bays, which is in process of being redeveloped pursuant to a board approval. Upon completion of the home construction, the applicant had sought a certificate, a partial certificate of wetland compliance for the dwelling in order to get the home CO'd with the understanding that they would file for a second certificate once the Conservation Board permitted swimming pool and patio were built. However, when the property was inspected, we found the site to be non-compliant in that the required restored naturally vegetated buffer had not been satisfactorily revegetated. We also found that a third level deck had been constructed on the seaward side of the home without authorization from this board. We also advised the applicant that the Conservation Board permit needed to be further renewed, and that we could renew such permit conditioned upon the landowner seeking a modified permit from this board to legalize that third level deck, as well as with the understanding that they would come forward with a supplemental buffer revegetation and native revegetation plan, and also that they would hand remove the excessive amount of floodborne debris, trash, and litter in the on-site wetlands. The third level deck is at a compliant wetland construction setback, and the applicant yet wants to go forward with the permitted accessory improvements. So this is a resolution to modify the existing wetland permit to allow the applicant not only to go forward with this project, but also to work out a satisfactory buffer restoration plan, which they have commenced work on.
Motion to issue the wetland permit modification.
Second.
Resolved that a wetlands permit modification be issued to Tiana HB LLC for the proposed project upon the terms and conditions set forth therein. All in favor?
Aye.
Opposed? CB 23009, 626 Dune LLC.
This wetland permit modification application relates to an existing residentially developed property on Dune Road in West Hampton. Previously, the landowner had obtained a permit from this board in order to construct a second-story addition to an existing home, requiring retrofit of the existing pilings. The permit also allowed for a demolition and reconstruction of decks, conditioned upon establishment of a covenanted wetland preservation area, and naturally vegetated buffer, as well as native landscaping. The applicant needed pyramid law relief, so filed a variance application with the zoning board of appeals, at which time the zoning board did not look favorably upon their application, and it was then recognized and acknowledged that the finished first floor of the existing home was considerably higher than required by FEMA, and that if they sought a modified permit from this board to demolish the existing first floor and reduce the height of the existing pilings and build a new dwelling at a FEMA compliant elevation, the degree of pyramid law relief needed would be considerably less. So the applicant was amenable to filing a modified project plan with the zoning board, and also agreed to make the necessary application to this board to demolish the entirety of their house and build a new home within the same footprint that was approved by this board, but at a lower finished first floor elevation, thereby reducing the amount of pyramid law relief. No other aspect of this project has changed, so this is a modified permit that can be approved without resulting in any new significant adverse wetland impacts.
Motion to issue the wetland permit modification.
Second?
Resolved that a wetlands permit modification be issued to 626 Dune LLC for the proposed project upon the terms and conditions set forth therein. All in favor?
Aye.
Opposed?
Motion to adjourn.
Second?
All in favor?
Aye.
Opposed? Thank you all.
All right.
Thank you, Peter.